In Scottish courtrooms, conviction rates in rape and attempted rape cases are much lower than for other crimes. It's in that light that the Scottish Government wants to pilot judge-only trials without juries. But the move is being met by a growing rebellion from criminal defence lawyers who plan to boycott the scheme because they say it would undermine the justice system. Despite the legal backlash, the Justice Secretary, Angela Constance, told STV's political editor Colin Mackay that she is determined to press ahead.
If lawyers don't agree to this, it can't go ahead, can it?
It's important that we all take a step back and recognise that only a fortnight ago we introduced landmark legislation to make the life of victims and witnesses in Scotland easier within our justice system. It is important that we have a debate going forward and that debate is inclusive of all points of opinion, but we do have to recognise when we look at the evidence around low conviction rates, around rape and attempted rape, and also the evidence about preconceptions about rape in juries, that we do need to do something different and that the status quo is not an option.
But to make this pilot work, you need the lawyers.
To make this pilot work, we need to pass legislation in Parliament, and then we need to, at a later date, bring forward particular regulations that will be subject to affirmative scrutiny. So we have a long journey to go. I am determined to proceed in partnership, to have a mature debate about what more we can do that will affect meaningful change within our justice system and for victims of rape and attempted rape.
But as it stands, lawyers are saying they will boycott your pilot. You can't make this pilot work without them, can you?
Well, I'm of course disappointed that some criminal defence lawyers disagree with the recommendations made by Lady Dorian, Scotland's second most senior judge. Recommendations that were brought forward in a spirit of evidence-based and also collaboration. And it's my job to continue to work across Parliament and work across the justice sector, but also to take on board the broader views of the people of Scotland, and that includes the needs and rights of women and girls.
But you have to accept that without the lawyers, you can't make this pilot work.
Well, we will see. We've got a long journey to go.
Do you think you could make it work without the lawyers?
Well, lawyers are crucial stakeholders. They're a crucial component of the justice system. We should remember that lawyers are not one big homogenous group. As a sector, they often have a range of views. Their skill-based necessitates that they are disputatious by nature, and that, of course, is to be welcomed when we are seeking to make...
But at the moment, they all seem to be opposed to this. Therefore, you have to accept that you can't do the pilot without them, can you?
I recognise, first and foremost, we're at very early days in the legislative journey of this landmark legislation. I also recognise that change is very difficult, particularly when we are attached to traditions. It is imperative that we have a debate and that we go forward in a spirit of partnership.
Angela Constance talking to Colin Mackay. Well, much of the opposition to juryless rape trial pilots is being led by the Scottish Solicitors Bar Association. Its Vice President, Stuart Murray, joined us to discuss his objections, along with the KC Simon de Rollo. He is an advocate who sees merits in the Scottish Government's policy. Simon, there is widespread opposition to these proposals, and you seem to be in a minority of lawyers. What do you think is the merit of this?
Well, I think I'm not sure I am in the minority of lawyers, but the merit is that this is an opportunity to scrutinise the way in which fact-finding takes place in rape trials. And it's something which has been given an indication that it's been something that's been put forward by Lady Dorian in a working group. And I think it's something that should be given a chance.
Stuart, Simon's saying he's not in the minority of lawyers, but the Scottish Government says the evidence is overwhelming that juries can be swayed by what they call so-called rape myths. Wouldn't judge-only trials help address this?
No, I don't think so at all. I mean, firstly, with the greatest respect to Simon, I would say that he was definitely in the minority, and certainly if you look at our members of the Scottish Solicitors Bar Association, it's very clear that every day more and more lawyers and bar associations are coming out in support of the boycott. The fundamental issue here is that there may require to be work done in respect of rape cases and attempted rape cases, but the work to be done is not to remove the imposition of jurors. Jurors are there for a reason. That's to provide a cross-section of society, not simply to leave it up to one judge to decide.
But isn't it fair to say that, as the Scottish Government does, that 84% of all criminal trials are held with only judges? What's the difference here?
I mean, that's a sort of figure that's been bandied about a lot by the First Minister over the course of the last few days. And of course, what I say is that's slightly disingenuous. That includes, of course, the entire gambit of criminal offences in Scotland, including the Justice of the Peace Courts, where judges that sit in those courts are not even legally qualified. You must look at rape and attempted rape cases as something an entirely different animal.
And Simon, the Scottish Government is trying to increase the conviction rates for rape trials, which stands at around 52%. Will this lead to more convictions, this pilot?
Well, we don't know, I don't think it's necessarily the most important aspect of this is improving the conviction rate. What is really necessary is that a reasoned decision is given to a complainer when an acquittal takes place. And also, I think it would be helpful that a reasoned decision is given to an accused person when a conviction does take place. So there shouldn't be, we shouldn't just simply be concentrating on the question of conviction rates in relation to this proposal. We should be thinking about a better way of fact-finding and a way of fact-finding which is capable of being scrutinised.
And when you talk about a reasoned judgment, forgive me, but my understanding of that would be the judge explains why he's taken this decision, or he or she's taken this decision.
Exactly.
It's not just a jury and it all ends.
Yes,
yeah.
I must say that, first of all, the Scottish Government's proposals are simply to have a pilot, and there's got to be an awful lot of discussion between now and any regulations being formulated as to how this should take place. My feeling about this is that there should be a panel of judges rather than a single judge. That's one matter that would take some of the heat out of the objections that have been put forward by the legal profession so far.
Stuart, doesn't there need to be some sort of reform, and perhaps, as Simon's suggesting, a panel of judges might be that? No,
that certainly would not pacify the legal profession. There are other issues which should be looked at outside of the court procedure, of course, and that could include, for example, the timeframes in which cases are taken to court, so that genuine complainers are not left hanging about for years before they're brought into court, the way that the Police Scotland investigate matters, the way that the Crown mark potential rape and attempted rape cases, and of course the way that the Crown deal with them once they decide to move that forward for prosecution and indictment. These are all issues which require to be looked at before any pilot takes place in relation to single judge rape and attempted rape cases.
And Stuart, this is a pilot case. What defence lawyer, would it be a risk for a defence lawyer to put a client up for this pilot study? Is that what the concern is, that somebody might be convicted under this pilot study that wouldn't under normal circumstances? Well, that's a concern. Also, the concern is if the pilot scheme eventually was deemed not to be fit for purpose, what would happen to anybody who'd been convicted under the pilot scheme? There are too many unknowns here, and what we still don't know about yet is if a pilot scheme were deemed to be appropriate and put in place, would there at any point be a means of consent for an accused person to take part in that? That certainly was the case when the government piloted the virtual summary trial system during the COVID pandemic. Of course, we're no wiser as to what will happen there yet. And Simon, can this go ahead without the support of most defence lawyers?
Well, it will require the cooperation of the legal profession. Clearly, the legal profession will have to agree to carry out their role. I think the reaction so far and some of the language that's been used, I would suggest, has been a little bit on the extreme side. I think what's needed is a calm and reasoned debate You can have a fair trial without a jury. That is possible. It happens all the time. And there are other jurisdictions in the world where this has taken place. There have been single judge trials in places like New Zealand. So this can be done, and there's no real reason why it shouldn't be done. I think that the legal profession should make an attempt to at least have a reasoned discussion about it.
And finally, and briefly, if you will, Stuart, what might persuade lawyers to take part?
Well, I think that lawyers, as I see it, will not take part in what is effectively just a social experiment. We won't subject our clients to that. I have to say that, just to come back at Simon briefly there, this is a reasoned debate. This is a calm, reasoned debate. That is how we conduct ourselves. We are officers of the court, and we will continue to act in a reasoned manner.
And there we will have to leave it. Simon, Stuart, thank you both for joining us in Scotland Tonight.
Thank you.
Thank you.